Welcome back to another episode with ByrdAdatto. Now, over the last few months, we've done about a half dozen videos on the Occupational Safety and Health Administration, otherwise known as OSHA. And during that, we were talking about what OSHA was supposed to be doing during pre-COVID, which is really, as an employer, based on OSHA rules, you have a duty to protect your employees from hazards like death or serious harm. Now, post-COVID, believe it or not much has actually changed. Like a lot of government agencies, OSHA has been playing catch up to COVID, and now they're trying to figure out how to take it head on. And they have just recently released some new memos or rule updates. And we have an awesome special guest who's joining us today. Michael, can you please introduce our special guest?
Courtney Cowan joins us today. She is part of our speaker team, and so back when there used to be these things called conferences, you may have seen her at one of those on stage speaking, and now that we're bringing those types of speeches to our videos, we're really grateful to have Courtney join us and bring some of her OSHA wisdom to everyone here. Welcome.
Hello.
Awesome. Thank you again for joining us, Courtney. And, as I was saying, one of the big issues, especially for our healthcare clients, is a lot of them are already required to comply with OSHA. And mostly today, we're going to be talking about if someone's injured on the job, there is a log that you're supposed to keep. A lot of our clients are familiar with something called the stick log, which refers that if RN sticks themselves with a needle or an MA, they actually have to have a log. So it's pretty straightforward. But it appears, based on what's going on with COVID, that OSHA now wants to expand that. And I'd love to hear what we've learned as to some of the new things that OSHA is releasing.
Yeah, so last week, OSHA actually published a memo that was talking about how they're going to start exercising their enforcement discretion over COVID-related cases, especially in the workplace, obviously. So it was really only a matter of time before this came out. The good news is, having to keep an illness or injury log, you're probably familiar with this process. So essentially what this new memo states is that all employers who are already required to maintain their injury or illness logs must determine whether an employee's COVID illness is work-related, and if so, they have to record those. Specifically, there are 3 requirements for if you have to record whether an employee got COVID on the job. First, it has to be a confirmed case of COVID-19 as defined by the CDC. The second is if it's work-related, i.e. an event or exposure in the work environment is what contributed or caused the illness. And the illness resulted in death, days off from work, restricted work or a transfer, any medical treatment over first aid level, or loss of consciousness. That's when an employer is going to be required to record that the employee got COVID-19.
So I think you said this, I want to be clear. Do all employers now have to track if there is a COVID case from an employee?
Yeah, that's a great question. The good news is no, not all employers. So if an employer isn't already required or has an obligation for this record keeping, then they only have to report to OSHA if there's a work-related COVID illness that resulted in death or an inpatient hospitalization, amputation, or loss of an eye.
All right. Well, this seems to be like a huge issue. Like, how can an employer know if the employee got COVID at work or in their personal life?
Yeah, that can be tricky, and OSHA actually thought about that. There's an inherent difficulty, especially since it's novel. We've all heard that's novel coronavirus. There's a difficulty in determining how someone contracted COVID. So OSHA is going to look at a totality of the circumstances to determine whether a sufficient investigation occurred, and this includes the reasonableness of the investigation conducted by the employer. So OSHA knows that not every employer is this huge corporation that can just throw money at a medical investigation, and HIPAA probably wouldn't allow it a lot of times anyways. So there's going to be the reasonableness. Did you ask the employee how they think they got COVID? You know, you want to respect the employee's privacy, but kind of get more information of what were the events leading up to that illness. So there's reasonableness in that investigation, kind of figuring out how they think they got it. They're also going to look at the evidence that's available, you know, at the workplace, as well as evidence of whether it actually occurred or the likeliness that it occurred at the workplace. So they're going to look at, were there several cases from employees that have been working in close proximity to each other and there's no other explanation of how they got it? Or are they working face to face with people on the daily? No one else they know has COVID. So again, it's sufficient investigation, but there's no one thing that points to how OSHA is going to determine whether it was a sufficient investigation.
So, follow-up question: if an employer decides that they need to record a COVID case, does that mean that they violated OSHA?
No. So OSHA has cautioned that recording of a COVID work-related illness does not automatically correlate or equal a violation of OSHA. With that said, employers will want to be mindful that any designation could be used as evidence against the employer if there is a workers' comp claim or if there's a suit for damages that's filed by the employee or the employee's family. So not per se a violation, but you still want to be cautious about recording it because that could be used as evidence in other related suits.
So it appears, you know, based on this, that employers need to be really careful about the investigation and how they articulate this in the documentation, because the investigation really will help protect them on the backside in the event there is ever a lawsuit.
Right.
Any other thoughts or questions, Michael, that you might have on OSHA, on especially with these new updates?
I would just reinforce what we've talked about before, that, you know, from a big picture, we have a pandemic going on. That's what this is about. And, you know, we have just a very unique sensitivity of employees right now. There is real fear as they are coming back to the workplace. And we have seen the correlation of an increase in reported OSHA cases. And so risk from a pure business perspective as it relates to OSHA is higher today than it ever has been.
Yeah, and on that particular note, actually, I saw something the other day that between March 16th and May 29th, OSHA has done 253 inspections of facilities, while last year in 2019 at the same time they did 5. So complaints are up and inspection is significantly up. And so that's why it's so important that if OSHA does come and inspect you, that you have your logs done correctly. Any other thoughts, Courtney?
I think, and the world's kind of on fire right now. So I know that employers are trying to do right by their employees and trying to follow all of these ridiculous new regulations and emergency orders. I think the biggest takeaway when I was reading this memo was that, yes, it's important to conduct investigations and record COVID-related illnesses. And I know a lot of employers are quick to do that. You still want to take the time, conduct a thorough investigation, because at the end of the day, OSHA said that if an employer is unable to determine that it was more likely than not that the employee got COVID at their workplace, then they don't have to record that. So just be mindful of that when you're going back to the workplace and your employees.
Awesome. Courtney, thank you again for joining us.
Of course, happy to be here.
And Michael, always good to see you. But until the next time, thanks for joining us.
Thank you.